ahead and get started. Anybody have any questions about anything? Okay, well today we're going to talk about cross-examination. And the starting point for me on this is, where is my thing? There we go. You know, it's been said that cross-examination, and this is from John Henry Wigmore, who is, or was, a professor of evidence at Harvard Law School back in the early 19th century, well, late 19th century, early 20th century. John Henry Wigmore said that it's the greatest legal engine invented for the discovery of the truth. Now, I'm not sure that's true or not, but cross-examination really is just plain fun. Once you learn how to do it with some reasonable competence, once you've got something to work with, and once you have developed some of the skills to be a good cross-examiner. Now, one of the kind of basic principles of cross-examination is that it is hard. It really is hard, and it's something that it's easy to do poorly, and that it's hard to do even moderately well. So it is very much worthy of your study and your work over the course of your careers to get better at it. What are the problems that you see with witnesses? On the one hand, some witnesses do tell the truth from the stand. Imagine that. They're under oath, and I guess we would expect that of them. But most witnesses tell some different version of the truth. Now, some of them outright lie, and they have good reason to lie because their son is on trial for murder, or because they themselves want to avoid a lengthy jail sentence in a criminal case, or you name it. People come to the stand and lie. And I remember when I first started as a lawyer, the lawyer I worked for said somebody's lying in every case. Well, I mean, I'm not sure that's really true, but the more I practice, and the more I think maybe it is closer to true than to false. And if you think about it, and I know those of you who have had me before have heard me say this before, that the reason we have courthouses is because of this recognition that people come to court and lie. If everybody just told the truth, we wouldn't need these courthouses to flesh out the truth from that which is true and that which is false. So I've always kind of thought in that regard that courthouses are to some extent temples to lies. They're there because we acknowledge that people lie. And then lots of stuff happens in between. The witness may tell part of the truth but omit other parts of it. The witness may shade and varnish. And it's the job of the cross-examiner to flesh this out, to not just tell the jury that the witness is not telling the truth, is lying, is omitting, is varnishing, but really to show it in almost a theatric way, in an interesting, compelling way, to show the jurors that this witness is lying, omitting, varnishing the truth. Okay, so where do we start? Well, the starting point for how to do an effective cross-examination really starts with how to do a direct examination. After all, a cross-examination is, at its basic, an examination of a witness. So all these basic principles still apply. Like, for example, the principles of achieving clarity, memorability, and credibility. Whenever you ask any witness a question, whether on direct or cross, you want to make sure that the jurors understand the point you're trying to make with the witness. That's the clarity. And a lot of times I've seen lawyers finish an examination and I'm like, well, what was the point of all of that? It's got to be very clear what the point is. And not only does the point need to be clear, it needs to be memorable. Because if they don't remember what you just did, it's as if it never happened. So you need to achieve clarity and memorability. And credibility. I've talked about this over and over again. Your rule one, your ethos. Remember, Aristotle said the most important aspect of persuasion was ethos, the believability of the speaker. The messenger matters. And when you're on cross, one of your principal goals is to show the jury, or if it's not a jury, if it's a bench trial, to show the judge to show the finder of fact that you're there to get to the truth. You're there not to waste people's time. You're there to ask just enough questions to get the point done. You're there to lead the fact finder to the truth. And that is your ethos, your rule one, your credibility. And in that respect, this examination, just like everything else you do in court, is about you. Serial position effect. You want to, and this is that basic principle that you've heard over and over again, that you want to persuade somebody, you want to put the most important point first, the second most important point last, and the stuff that you don't like so much in the middle. So, again, kind of hard to talk about this in particulars with our case, but generally, you figure out what the main point is you'd like the jurors to take away from your cross-examination, and do it right when you stand up. No warming up with stretching your legs with kind of basic general information. Just stand up and make the first point. Show the jurors whatever it is you want to show them. And then do the rest of your work, and then at the very end, finish with your next best point. Outline answers, not questions. This is I think one of the most fundamental principles of asking good questions, is not writing out questions. Why? Because if you write out questions, you're going to read them. Write out the answers you want. For example, if you want the answer from the witness to be that the light was red, don't write, what color was the light? Write, the light was red. Well, then you'll ask the right question. Now, oddly enough, on cross, as we'll talk about, most of your questions are going to be in the form, or going to be leading, which means you really almost will be reading the answers to them. You won't be saying, what color was the light? You'll be saying, the light was red, wasn't it? So writing out the answers really even makes more sense here on cross than it does on direct, although it makes perfect sense then as well. And then finally, just like in direct, or like any time you're standing up to examine a witness, have your exhibits ready. The last thing anybody wants to see and sit through is a lawyer fumbling through her exhibits. If you know the witness told the police officer that the light was red, you better have the witness's statement to the police officer, if it's an oral statement, ready, queued up to press the button on your computer. So the minute the witness says, oh, I told the police officer the light was green, bloop, it'll play out then immediately for the jurors that this witness said something else. Zora.
So at this point in the process, we have already presented our evidence, so we don't have to go through the whole rigmarole.
Yeah, for purposes of our simulations on Monday, our performances on Monday, we're going to assume that the witness has just testified for your opponent and has said all of the things you would expect they would say to support their case, and you're going to rise, scoot your chair back, and cross-examine the witness and make whatever points that you want to make to show that the witness is lying, omitting, shading, etc. All right, and again, on cross, it's critically important. In fact, I don't even put a question on my cross-examinations, rarely, unless I've got an exhibit that proves the point. Why? Because this is a battle between me and the witness, and the whole point is, when I'm done, I want the judges or the jury to think that I know what I'm talking about, and that the witness is trying to shade, omit, varnish, lie, etc. So if the witness gives me an answer I don't like, I'm going to put the witness back where the witness belongs with an exhibit right away. So you have to have them at the ready. This is all about you. Here I go again. I know I keep saying this over and over again. I just talked about it in the context of ethos. You want to stand up and you want everybody staring at you. Because this isn't really so much about the witness. It's about you showing everybody that the witness is lying, omitting, varnishing, whatever it is. So this is your chance. You need to position yourself in the courtroom, use your voice in a way that draws attention to yourself. Now, direct is very different, because direct, you want to fade into the background and have everybody like your witnesses. Right? Because remember, you're crossing your opponent's witnesses. You don't want them to focus on them and like them. You want them to focus and like you and your witnesses. So when your witnesses are on the stand, you fade in the background. You kind of talk in a more subdued manner. You talk maybe in a lower tone of voice, a little less animated. because you want the witness to be the star. On cross, just the opposite. You want to be the star. All right, so the focus is on you. And this really, even though it's last on my bullet point, I really think it's the most important rule. Don't cross-examine a witness just because it happens to be your turn. Okay, the direct exam's over, that means it's my turn. You better have a purpose. And so many lawyers stand up and cross-examine just because it's their turn. Sure enough, it's going to be your turn, but you better have a purpose. So you have to have a theory of the witness when you stand up, and you have to have a goal. And then when you have achieved the goal, however short a time it takes, then you sit down and you're done. So figure out what the theory is, what your purpose is, what you want the jurors to take away from your 5 or 10 minutes up at the podium, and then do everything with that in mind. All right, so in your kind of checklist, and I really have checklists that I use when I'm preparing a cross-examination for every witness. I say, okay, well, what do I want to do with this witness? First of all, is there anything that I can do constructively? This is where the witness is going to, and here I've got my little man with a hammer for building. I want to see what I can get from the witness that's going to help my case, facts that the witness has. Like, for example, suppose in my hypothetical car crash case, the witness who said that, and let's say I represent the plaintiff, that my light was red. So he's been called by the defense lawyer to show that my plaintiff ran through the red light. And I know he's going to say that because I've taken his deposition. But he also says that it was raining that day. And that fact may help me. But nobody else really has mentioned the weather. But I know he has. So I might stand up and then not lead with that. But at some point during my exam, I will ask him, by the way, it was raining that day, wasn't it? Yeah. The streets were slick, right? Yeah. So those are constructive cross points that I'd make with him. They help my case. I'm not, and you know, again, lawyers are kind of hypocrites. God knows I am. I talk out of both sides of my mouth as a lawyer. That's what we do. I'm trying to suggest that this witness might be lying or shading or varnishing or omitting as to those facts that hurt me. But as to this fact about raining, I'm trying to suggest that, oh yeah, okay, well if he says it was raining, of course it was raining, because that's what the witness just said. It's hard to do that, but you do that. That's what you're doing on constructive cross. Now there are times where perhaps a witness, you got nothing to beat him up with. You might just stand up and cross him on facts that help. Or, you know, I don't have it on here, but I'm gonna change my slide. On facts, on a cross that just kind of neutralizes the witness. So, you know, the constructive cross is fairly straightforward. You elicit favorite evidence, emphasize and corroborate favorable evidence, and, you know, basically that's it. And then you move on to destructive cross. But I do want to, and again, my next iteration of this slide is going to have this bullet on there. I think there is the cross, a good cross that can often be done, which I would call a neutralizing cross, which is just to show the jurors that the witness didn't touch you. And for example, I mean, I've tried a bunch of murder cases, and in every murder case, the prosecution will call the coroner to testify for half an hour about all the holes in the victim. Went this way, went that way. And there's rarely a dispute as to the victim being dead. Everybody agrees the victim's dead. And that the victim, if it was shot, he was shot straight in the forehead at point blank, that he was shot straight in the forehead at point blank. So, for example, I would stand up right when the coroner takes a stand and say in front of the jurors, Your Honor, we'd stipulate that the victim is dead and that the victim was shot point blank with a .45 caliber pistol. We'll stipulate to that. No, Your Honor, we don't want to stipulate that. We want to call the coroner. And then I'll sit down and so we'll go on for 45 minutes, and then I'll stand up and I'll say, just again, this is all about me, right? So, Mr. Coroner, the victim is dead. Yeah. The victim was shot straight in the head with a .45 caliber pistol, yeah, and you have no idea whether the defendant, my client, did it. You know? Thank you. So what was the point of that? To show the jurors that we just wasted 45 minutes of our lives for nothing. And the whole issue in this case is whether my client put the .45 caliber pistol at point blank and killed this victim, who we all agree is dead. So again, I think I like that cross-examination because I've done it a bunch of times, and it comes off pretty good. You know, it just shows that it only takes 5 minutes. No, it takes 1 minute, and then you sit down and you've made some ethos points, right? Now, a lot of lawyers would just say, no questions. Well, I don't want to say no questions, not just because it's my turn, but because I want to score some ethos points. I want to show the jurors that I'm not a time waster, and I want to get to the truth about what happened in this murder. We need a murderer to catch, what we need to do here, not to waste time. So anyway, I think that neutralizing cross can be very effective. And again, I'm not going to tell a lot of war stories. I'm just thinking about another one that similar to that, where for at least an hour, the U.S. attorney put on evidence of CSI evidence about this gun and whatever, and it turned out he had the wrong serial number on the gun. Now, I knew it was the gun, but he kept on talking about serial number so-and-so, so I stood up and I said, all your testimony's been about serial number, blah, 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 blah. Yes. So look at the serial number on this gun that was found at the scene. Look. That's a different serial number. Yeah, but it's, but I'm sure it's the same gun that was at the scene. I know it was. And then my only question to him was, do you find it acceptable in a death penalty case to be making mistakes? Well, all he had to say was, he couldn't say yes. He just said, no, it's not acceptable. And I sat down. So I wasn't trying to make up that this wasn't the gun, it was the gun, but I just wanted to make the point that there was some sloppiness, and they were making mistakes. So, all right, destructive cross. This is what you generally think of. Now remember, we've just talked about constructive and neutralizing cross. So this is just the third variety of cross, but this is generally what you think of as what cross-examination is all about. You're going to get up and destroy the witness. To show the jurors that this witness is not worthy of belief. Well, the first type of destructive cross is what I'd call elements of competency. Now, those of you who are in my evidence class know we talked about elements of competency. And to be a competent witness, what do you have to do? Well, you have to perceive something with your perceptor devices, like your eyes and your nose and your ears and your senses of taste and smell. You have to perceive something in the real world. Then you have to remember it. Then you have to recall it. And then you have to explain it to the jury, right? So elements of competency cross is going after the witness for lacking some element of competency. And this is the key. A witness who you cross on elements of competency may be a very nice person. Suppose that there was a brutal murder on Bourbon Street and the witness who just testified was a nun from the Ursuline convent who was walking by and saw the murder and said that your client, the defendant, did it. Well, why would she lie? She's a nun, and she doesn't know any of these people. It's not like she's got an animus out for my client, the defendant. So when I would stand up to cross-examine her, I wouldn't try to make her out to be a bad person. She's not. Wouldn't make her out to be a liar. She's not. But she didn't have her glasses on that night. So we all make mistakes. And if we need glasses to see and we don't have them on, it makes us less credible as a witness. Not because we're lying, but because we just didn't see what we thought we saw. So my whole cross-examination on her might be on that. Or, for example, if you're cross-examining a witness who said that she was working at a restaurant 2.5 years ago and she saw the defendant come in and go out a couple of days before the robbery. Well, gosh, that's a long time ago. Think about all the people who came in and out of that restaurant. And you would suggest to the jurors that maybe she doesn't remember it being him. Or maybe since the restaurant was dark. And you know this line of cross-examination, and particularly in victim cases, violent crime cases. It was dark, you were scared, the gun was in your face, you didn't have your glasses on, it happened quickly, you know, we could go on. But those are all cross-examinations on elements of competency, that kind of inability to perceive as well as you maybe needed to perceive. Or you didn't remember as much as what you thought that you remembered. And, you know, maybe oath and communication are the other aspects of competency. I don't really know how to work that into a cross-examination, but I put it up on the slide because if, for example, if you had a witness who didn't understand the oath because they were a young child, for example, or couldn't adequately communicate, I don't know how that would happen, that would be fodder for cross-examination. All right, the next category of destructive cross-examination, and I don't want to go into a whole lot of detail on this because Professor Lescen is going to go into more detail on this, impeachment, next week. So what is impeachment? Well, impeachment, and if you're going to impeach the witness, your theory of this witness is that this witness has come to court and has taken the witness stand and is intentionally, not mistakenly, but is intentionally trying to mislead these jurors. To use the technical term, your theory of the witness is that this person sucks. They're a liar. It's intentional, an intentional effort to mislead. So you can't stand up and do this unless you've got some bullets in your impeachment gun. Last thing you want to do is to fire an impeachment bullet at someone and miss. Because then what does that do? It makes you out as the bad person. If you're calling somebody a liar and you can't show it, you shouldn't be doing this, right? You should be sticking to the other areas of cross. Because you don't need the person to be a bad person to do those sorts of cross. But to do impeachment, you have to have something. All right. So what are the different modes of impeachment? Well, first of all, you might consider impeaching a witness with prior inconsistent statements. Now, Professor Lescen will go into more detail on kind of how mechanically you do this, and it's kind of difficult to do it with some facility. You have to kind of get used to it. But the long and short of it is, and the point that you're making to the jury is, today he's come and said one thing, but on the scene he said another. And there's only one truth, so if he's saying that the light was red today and he said it was green back on the street, he's not to be believed. Right? Because people who we believe say the same thing, because there's one truth. So what you want to do is essentially ask the witness, now, Mr. Witness, you just told these jurors that the light was red, didn't you? Yeah. But that's not what you said right after the accident, is it? I mean, that's a simple setup, right? And it makes it very clear to the jurors exactly what I'm doing. I don't care what his answer is. I hope he says, no, that's what I said. Because then I get another lie, right? Because I'm not going to ask him that question unless I've got his statement saying that the light was the different color. Then I get to play the statement. The jurors get to hear that back then he said something different. And now he just said he didn't say something different. So I got two lies for the price of one. If he says, that's different from what I said at the scene. Well, then I've got that. And then I still might want to play the statement just for grins somehow. But prior inconsistent statements. Now you see this a lot, really. Now you have to have you have to have the theory. Sometimes people make inconsistent statements because they're simply mistaken. Well, we don't want to roast those people on the spit for that. So you have to have the right theory as to whether or not the witness is saying something inconsistently just out of a mistake, because we all make those, or because he's lying. So you gotta be clear on that. And that'll guide your whole demeanor in conducting the cross. You wanna show the witness, the jurors, that the witness has some reason to deceive. So, ma'am, you just testified that your son was at home when the bank was robbed. That's what you just told these jurors, right? Yeah. And you're his mother? Yeah. You would lie to save his life, would you? Well, you don't care what the answer is, right? I hope she'd say yes. My mother better come lie at my murder trial for me. And the jurors will think the same thing. She better. What else is a mother gonna do? So, again, very simple point, and I wouldn't beat her up, because of course she's there lying for him. That's what she's supposed to do. She's his mother, right? So, again, you have to have a good theory of the witness. Last thing, how bad would I look if I said, yeah, you're lying, because you're his mother, you're lying. No, they get it. The jurors get it, they understand it, and they sympathize with her, because I hope they would lie for their kids. But you just want to show, reason to deceive. Why do people have reasons to deceive? Well, because they have an interest in the outcome. Like, for example, if they're the plaintiff, they want the money. They may hate this person, they may really like this person. Prejudice is kind of when you hate somebody for no rational reason. Interest or bias is when you really like somebody for no rational reason. So you want to just pull out those rational reasons, show them to the jury, and look, they'll figure it out pretty quickly. Let me ask the plaintiff. Right? Now, you just testified that your light was green. You would like to win this case, wouldn't you? You'd like to get a couple $1 million from the plaintiff, wouldn't you? I mean, she's just going to say yes. So again, just very simple questions that just point out what's going on here. Now, this is bad person cross. This is when you're not kind of going after anything particular to this case, but you just want to show that this witness is the kind of person who you wouldn't really trust. Prior convictions. This is the whole premise. If somebody is a convicted criminal, they're bad. Somebody who's bad should not be believed as much as somebody who is not a convicted criminal. Back to, and I'm not a war storyteller, but here's just a quick example of this. In a murder trial that I had in federal court, every witness who came to testify that my client was the shooter came in an orange jumpsuit. Every one of them. And my cross of them was, I'd start with, Mr. Smith, you're wearing an orange jumpsuit today. And the jurors would kind of start smiling after every time, because I would start every cross with, you're wearing an orange jumpsuit today. Yeah. And you're wearing that because you're in jail. Yes, and you would like to get out of that orange jumpsuit one day and put on some real clothes, wouldn't you? Yeah. You'd like to leave jail, right? And you've talked to the prosecutors. So, you kind of go through how they are not only a convicted criminal, but they also have an interest in their testimony. They have an interest in leniency. And then on cross, I remember the judge had a jury instruction that said, proof beyond a reasonable doubt is proof that you would rely upon in making the most important decisions in your life. So on closing, it would be, I think I remember saying something along the lines of, the judge is going to tell you that there is not proof beyond a reasonable doubt unless you are comfortable enough with the evidence to make important decisions, the most important in your life. Well, let's just not even make this an important decision. Your doorbell rings at 11 o'clock this morning, one night, and you look through your peephole, and who do you see? Well, you see all these guys who came here today, and they've got their jumpsuits on. There's John and Frank and Joey, and they say they just want to come in and use your phone because their car is broken down. You going to let them in? That's not even the most important decision of your life, but the prosecution wants you to believe them, to rely upon them, that they're telling the truth. Not about wanting to use your phone, but about my client being the shooter. They're criminals. They're not worthy of belief. That's the point. Simple. Prior bad acts. This is if somebody's done something bad, you know, shoved an old lady over at the crosswalk, no conviction, but now these are harder as an evidentiary matter to be able to get into evidence, but you know, you think about these and see if you can do any of that. Bad character. Now this is junk evidence, I think, but you can, as you can see in the federal rules of evidence, state rules, you can call character witnesses who can testify about another witness's reputation in the community for truth-telling. Now, again, it's junk, but it's just on your checklist of things to consider. All right, so again, Professor Lessin is going to deal with impeachment more next week, but I wanted to talk a little bit about impeachment just to kind of put it into the context of cross-examination in general. It's just, and really the most important takeaway, I think, is that it's not the end-all, be-all. It's just one possibility for what you do in cross. And the other point is be very careful with it, because don't do it unless you got something to work with. No talk on cross-examination can occur in America without talking about the 10 Commandments of cross-examination. Even if I didn't. Why? Because everybody talks about it. And what are they? Well, the 10 Commandments of cross-examination come from a famous speech by Irving Younger, and that's Irving Younger. He's dead now, but he was a prosecutor and a judge in New York City back in the probably 50s, 40s, 60s, something along. But in the 70s, he gave a series of classic speeches to the National Institute, or for the National Institute of Trial Advocacy. And they were recorded on these old grainy videotapes. And everybody who grew up taking trial advocacy in the 80s was forced to watch the Irving Younger tapes. And I'm sure they're not on VHS anymore, or beta. Those don't exist anymore, but I'm sure they're out there. I haven't looked recently, but if you get a chance, look for these on YouTube and see if they're there, Vimeo, wherever you look for your media, your videos these days. They're classic, they're great. And a lot of what I do as a teacher, I've ripped off of Irving Younger, I've got to say. Just plain ripped off of Irving Younger, because he's got, everything he says is absolutely right, and he says it very well. So what I'm going to do is kind of the rip off from Irving Younger, and I'm going to tell you what Irving Younger says are the 10 Commandments of cross-examination. But in the interest of time, we're going to do 7 of them, because I think the other 3 are silly. I'm not even going to tell you what they are. So I really only agree with 7. So here they are. And I'm going to say it like Irving Younger says it. Be brief! And then he moves on. How about that to make the point? And by being brief, I mean with the witness, because, and this is what he says, you stand up, you do your cross-examination, you sit down. Why? He says, because you're probably, this is his words, you're probably fucking it up. So you want to sit down before you fuck it up too much. Makes perfect sense. So you breathe for the, use short words. Use nickel words. Don't use dime and quarter words. Use short words. Use short sentences. Don't say, no, the traffic light at the intersection, it was not green, it was really red, wasn't it? Instead, the light was red. Yeah, I mean, there it is. The light was red. 4 words. No intersections, signaling devices. I mean, it's a boom, boom, boom. Be brief with words, witnesses, sentences. Usually use leading questions. Now, this is important. In fact, when you start out, almost always use leading questions. You know what a leading question is. It's a question that has the answer in it. Now, you typically would use, to make a question leading, you would typically end it with something like, isn't that true? Or isn't that correct? Isn't that right? That's correct, isn't it? Like, for example, and when I teach this with Nita and some other groups, we make the students describe the room using leading questions. So you would say things like, the exit sign is red, the podium is on the left, The clock is on the wall. The walls are brown. There's carpeting in the front row. The seats are folded. So I am conveying information to you. And I would just take that same demeanor and turn it into questions with the witness. The podium is on the left. The clock is on the wall. The exit sign, red? Now, I could say the exit sign is red. Isn't that true? And you might do that every now and again, but understand that you've got this whole range of your voice. And you can take any declarative statement, assertion, that's the evidence professor in me, and turn it into a question just by raising your voice. Instead of saying, the exit sign is red, you could say the exit sign is red, the seat's folded, and sometimes I'll get this, and I got this in a hearing about 3 weeks ago. Is that a question? And I looked at the hearing officer, it was a disciplinary thing, and I looked at them, and the hearing committee chair says, of course it was, he's asking you questions. So, again, don't worry that you're not properly phrasing it as a question by just using your voice for the question mark. Because, again, you can do it that way. So usually you use leading questions. Now, why? Because all you would, in a dream world, all you want is a witness going, yes, yes, yeah. No, it didn't happen like, no. You're right. Mm-hmm. You got to answer yes or no. Yes. See, that's the best, that would be the best way to have a witness on cross. Why? Well, first of all, you are choosing all of the language and the words to describe everything. And you're not letting the witness put his varnish or his shade on it. You're in control. It shows that you know the facts. And part of this is just showing off for the jurors that I know all the facts. I know all the facts. I know that the light was red. I know that the seats are folded. I know that the exit sign. And it just, again, all ethos building. And as long as you got all the facts right, all you're going to get is yes, yes, yes. And then you'll throw in something else to get a no from, like, you weren't going to work that night. You know he wasn't going to work. He said he was going to work, but you got a document showing that he was going to the movies. And he never showed up to work that night. You weren't going to work that night. No, I wasn't. There you go. You hope he says, though, yes, I was. Right? And then you go after him to show the jurors that he just lied again. He was not going to work. He was going to the movies. All right, so usually use leading questions. Listen to the answer. Because usually, I mean, sometimes you're so worried about what's going to come next out of your mouth, because again, it is all about you, it's true. But you got to make sure you're getting what you need, and that he's not throwing you some more bones, some more stuff to work with. It's great when the witness will maybe say something when you ask him, the light was red, wasn't it? Yeah? Okay, well, did you hear that? A little uncertainty. A little uncertainty. You got to be listening. Wait, now you kind of said that in an uncertain way, didn't you? Yeah. And then, again, just by listening to that slight variation in the way he said it, it might give you something to work with. I mean, you might just ignore it, but it might give you something to work with. Who knows? All right, so listen to the answer. Don't quarrel with a witness. This is hard not to do because you're mad at this witness maybe because the witness is lying and it's really getting under your skin, and the witness won't give you the answers you want, so you want to argue with them. As Irving Younger says, don't argue with a witness, don't quarrel with a witness. And the anecdote he tells in his lecture is from the Nuremberg war crimes trials in Nuremberg. And all the German people German officers from the concentration camps and whatnot were being tried. And they were all asserting the Nuremberg defense, which is we were just ordered to do it and whatnot. So anyway, So Irving Younger then goes and says, there were 3 prosecutors. There was a French prosecutor, a Russian prosecutor, and an American prosecutor. And then he went on to say all kinds of politically incorrect things we couldn't talk about. Like he said, the French prosecutor, everybody fit their national stereotypes, he said. The French prosecutor was very debonair and charming, but had utterly no substance. And the American prosecutor was very well prepared, but didn't really have any flair to him. The Russian prosecutor acted like a tank, and he would stand up and he would ask the witnesses question. And after every question, he would say, "Do you confess yourself to be a fascist pig?" He says, if you ever hear yourself saying a question like that, you're quarreling with the witness. Don't do that. So you just ask the questions and don't argue with the witness. Now this is one that I'm not so sure I agree with. He says, don't let the witness explain. Like, for example, if you were to ask the witness something along the lines of, you didn't see the color of the light right at the time of the accident, did you? No, but, no, don't explain! No! Don't explain! It's a yes or no question. That's what a lot of lawyers will start doing, right? Witnesses said, no, and then they start to try to explain. And that's apparently what you're supposed to do, but this is the problem. The problem is it erodes your, rule 1, your ethos. It shows these jurors that I'm afraid of this, that I just want them to say no. He didn't see the light at the time of the accident. But you know what's going to happen? Yeah, okay, thank you. No. Okay, let's move on. The other side is going to stand up. And they're going to say, didn't you want to explain that? Yeah, I didn't see it right at the time of the accident because I turned my eyes because I knew that the cars were going to collide. But about half a second or less before, it was red. Well, now what does that look like? You look like a fool. You look like they're trying to sell these jurors a bill of goods. You don't care about the truth. You just want your right answers. So be very careful about that with don't letting the witness explain, because they're going to explain, and you don't want to be the person that is getting in the way of the full truth. Yeah.
Professor Lissette, I don't want to take too much of your time from your lecture, and we can always talk about this after class. But formerly I had been criticized because I don't control the witness very well.
Yeah.
And so last class I actually tried to control the witness and do precisely what you're just telling us not to do. And so I was criticized negatively for that. But I did that almost purposefully to kind of see what kind of feedback I would get, because I honestly don't know why I was criticized like that. Because I see their point. I accept the criticism. Just previously, I asked questions during cross-examination, and I just allowed them to explain, because
Let me start again. I always start my answer to this question, because your question, in the generic sense, is a very common one.
okay.
And this is it. Cialino, you're telling me one thing, but on Monday night I hear something else from my 2 adjunct professors, right? That happens every... Wait, it's okay. First of all, this is an art, not a science. And there are times in the same examination where you might want to try to exert a little bit more control and rein the witness in a little bit more, and other times. So it's really kind of hard for me. I don't disagree with them, and I don't agree with them. How's that?
Okay.
You do have to control the witness, and the best way you can control the witness is by asking leading questions with answers that you have in exhibits. So if you say, the light was red, and the witness says, well, it was raining that day, and I was out there, and they start going on and on and on. Now it's time to control that witness, and to show these jurors that this witness is wasting everybody's time.
Okay.
So I would say, this is the control I would say. I wouldn't say, Judge, would you please instruct the witness to answer the question? I might get to that. I would say, this is exactly what I would do, because this is a common problem. Light was red, right? Well, it was raining, and I looked at it for a little bit, blah, 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 blah. I'll say, are you done? The light was red, wasn't it? Right. And then I At that point, I'm not saying, yes or no, yes or no. Like, I just ask it again. And if I get the same old answer, it was red, wasn't it? And then if I don't get it again, then I'm just gonna go to my exhibits and show that it said the light was red before or something. That's the way to control, maybe, that's the way I would like to control, but you can get control help from the judge occasionally too.
Thank you.
Yeah. 6, don't permit the witness to repeat direct testimony. I'll never understand why lawyers do this. They do this when it's just their turn to cross, and then the witness has just poked them in one eye, and what? They get the witness to stand up, and they ask the questions, and the witness says something, says the same thing again, pokes him in the other eye. Then they gotta find their way back to the seat. So, remember, witnesses are on direct because they're gonna poke you in the eye. Don't have them do it again. It hurt bad the first time. So don't do that. Unless they've said something that was really, the times you will have them repeat is if they've said something really good. That's the constructive cross corroboration. Or 2, if they've said something really stupid. Then you're going to want to replay that and then hit them again with it. And this is kind of similar to the don't permit the witness to explain. This is the don't ask one question too many. I really disagree with this because, for example, and the classic example is Abraham Lincoln. When he was a lawyer, the other side asked the witness on cross, now you did not see my client bite the ear off the victim during the fight, did you? No. Thank you very much. No further questions of this witness. Abe Lincoln stands up, looks at the witness. The cross-examiner didn't ask one question too many, but what does Abe Lincoln ask? How do you know that the defendant bit the ear off the victim? Because I saw him spit it out. Well, there you go. Now how stupid does that lawyer look? That he didn't want the jurors to, by not asking one question too many. So, well, there it is. Those are my thoughts. Most of all, have fun. This is really great fun. I think this is really the funnest thing to do in all of law, is to do a cross-examination. So enjoy. All right.